Hello, Carla Hartley here. I am discussing today the Community Opportunity Doctrine. The Community Opportunity Doctrine is unique in California to the family code cases that come before it, and within the family court cases that we have, it is further unique to the dissolution of marriage cases, your divorces. The reason for that is without a marriage, you don't have a legal community, a community property estate in California, or the duties to manage in the highest good faith and fair dealing with the other party in the context of marriage, which is what we have in California's marital dissolutions. So the Community Opportunity Doctrine pretty much holds that the spouse that has a separate property fund and wants to invest has to first make an offer or has an obligation to use community funds for that good investment. Now, this is kind of intricate, but I'm going to use a really simple example. Say the community, husband and wife, the community has $100,000 sitting in a bank account in savings, and let's say wife has $100,000 of her own that she has, for instance, inherited, sitting in a savings account that does not have husband's name on it. It is her separate property. So this business opportunity comes up. I don't care what it is, any kind of business opportunity. And the wife, in this case, wants to invest her separate $100,000 in this. Well, the Community Opportunity Doctrine says that the community gets that opportunity first. So what's supposed to happen is husband and wife are supposed to have a discussion and decide whether or not to use community money for this or not. And I'm just going to go out here and say that if you did have this discussion, you better have some kind of resolution in writing, because we've hit a point today, once litigation starts, and once that $100,000, for example, has turned into $500,000 as a result of a wise investment, what you're going to have is different memories. One party is going to remember the spouse that was the other part of the community said they didn't want any part of it. The other party is going to say, oh no, I said I did, but you used your separate money anyways. So get it in writing. Memorialize your stuff, get it in writing. The $100,000 gets invested, becomes $500,000. The separatist is going, oh, this is my $500,000 of separate property. And if you cannot prove that the other person in the community said, no, you are not investing our $100,000 in this, then you have violated the Community Opportunity Doctrine. And the remedy for that would be to find that the $500,000 was community money, but to give the separatist a reimbursement for that $100,000 so that the separatist is also made whole. That is so oversimplified, it hurts my teeth. But I want to get the general concept of the Community Opportunity Doctrine out to you, so that if you're looking at something and thinking, I should have had a chance at that, or this person throughout the marriage has just tended their separate property estate while just spending all the community property money on whatever, that becomes problematic. Now, for the Community Opportunity Doctrine to apply, the community has to have had money available to invest. And this is going to go into tracing and into reimbursements and into all sorts of other stuff that I'm not getting into in a brief video context. I just want you to know that the Community Opportunity Doctrine is out there, that it has been out there for many years, and it has been used to equalize the parties' estates when they separate upon divorce in many, many cases. I hope this has been helpful. I hope you guys have a good day, and I hope to see you again soon.